Can a state legislature draw election lines in an obviously, blatantly political way to favor one party over another?
Good morning, Senator Kennedy. My understanding of the law is that issues such as partisan gerrymandering are considered political questions.
Yes, sir, but can you answer my question first, if you don't mind? Because I've got 6 folks here in 5 minutes. Can a state legislature do that?
Senator, under the justiciability issue of political question, I believe the Supreme Court has held that those issues are political and not something that the court can review.
So is that a yes or no?
Senator,
Senator John Kennedy is known for his sharp wit, no-nonsense questioning, and ability to expose unprepared nominees in seconds. But in this jaw-dropping exchange, even Kennedy seems taken aback. What started as a routine round of questions quickly turned into a masterclass in legal confusion. Buckle up, this is one of Kennedy's most revealing interrogations yet. The exchange began with Kennedy making it crystal clear. He wasn't interested in the nominee's personal beliefs. He wanted to know how this potential federal judge thinks. And his first question? A basic one in constitutional law. Can a state legislature blatantly gerrymander to favor one party? The nominee's answer? Well, it's something you won't believe, so seat back and let's dive right in.
Tell me about the political question. I'm sorry. We were just talking about political questions. Tell me about the government speech doctrine. You'll see that a lot in federal court. Tell me about the government speech doctrine.
are you referring to under First Amendment, Senator?
Yes.
So my understanding under the First Amendment that there are particular forms of speech that, depending on if it's content-based speech or content-neutral
Yes,
speech.
so that's on the private side. I'm talking about the public side. Do you know what the government speech doctrine is?
Senator, my 20-plus years practicing civil litigation and 2.5 years on the bench, I have not had the opportunity to hear or litigate any matters involving that doctrine. But certainly if it comes before me, I would thoroughly research it.
Well, you're going to have to bone up on it because you're going to see a lot of it. Let me put it another way. Does government have free speech rights?
Does government have free speech rights?
Yeah,
Well,
we know you and I do, but does government itself have a right to free speech?
Senator, I would have to understand more of the facts of a particular challenge.
It's very simple. I'm not talking about individuals. We know that the government, state or federal or local, has to be very, very careful in restricting our right to free speech. I'm asking you about government. Does government have the right to free speech?
Are you referring to just an individual who serves in
No,
government?
I'm talking about somebody speaking for a government. If a governor stands up and says, I'm speaking for the state of New York, does government have the right to free speech? Yes or no, if you would?
Senator, again, in my 20 years of litigating civil litigation matters and 2.5 years on the bench, I haven't had specifically a case on that
I know,
particular
but
matter.
have you thought about it? I mean, there's a whole body of case law out there, my gosh. Did you study that in law school, Judge?
I'm sure I did, Senator.
Okay. Well, let me put it another way. If Senator Lee designs a special license plate that he wants to give people the right to purchase and put on their cars in Utah, and the government says no, and Senator Lee says, but these other folks design their own license plates, and the government of Utah says no. Can the government of Utah do that?
Well, if the government is restricting certain kind of speech, content-based speech, it would have to undergo a strict scrutiny analysis.
No, it wouldn't. No, it wouldn't. That came up in Texas. That's what the government speech doctrine is. Somebody in Texas said, I want to put a Confederate flag on a license plate. And Texas said, nope. And he sued, said just what you said, very famous Supreme Court case. And the Supreme Court said, government speech, government can do that. Do you know what well, strike that. Let's suppose there's a park, and that park has monuments in it. And Senator Lee says, I want to put my monument in that park too. I see all these others you let put in there. And government says no. Who wins? I'm sorry, Mr. Chairman.
Senator, I would have to review more facts of the case to determine.
You don't know who would win that?
Senator, I'd have to see more details from the case to determine the facts behind it to make a proper ruling on that type of a case.
Wow. Okay.
Senator John Kennedy once again cut through the fog with piercing clarity. This wasn't about partisanship, it wasn't about gotcha questions, it was about competence and the responsibility that comes with seeking a lifetime seat on the federal bench. Throughout this exchange, Kennedy didn't ask obscure fringe hypotheticals. He posed foundational questions, ones that any federal judge should not only expect, but be eager to answer. The government speech doctrine, the political question doctrine, landmark cases decided by the U.S. Supreme Court. These aren't traps, they're basic terrain in the legal landscape, and yet, the nominee couldn't navigate them. What Kennedy exposed wasn't just a lack of preparation, it was a lack of constitutional grounding. When a nominee cannot explain whether government has free speech rights or fails to recognize Supreme Court precedent that governs that very issue, it raises serious concerns, not just for senators on the Judiciary Committee, but for every American who depends on the courts to uphold the Constitution with clarity and integrity. Senator Kennedy didn't shout, he didn't grandstand, he simply asked, and watched as the answers fell apart. That's not intimidation. That's accountability. In an era where judicial activism, political gamesmanship, and ideological rubber stamping threaten the impartiality of our courts, Kennedy's line of questioning reminded us why confirmation hearings matter. He didn't just reveal a weak nominee, he reminded the nation that the robe must be earned, not gifted. So, when critics accuse Kennedy of being too tough, the real question is, too tough for whom? For unprepared nominees? Or for those who think the Senate's job is just to wave nominees through? The truth is simple. We need more John Kennedys, lawmakers who respect the law enough to demand excellence from those entrusted to interpret it. Because when it comes to our courts, close enough isn't good enough. In the end, Senator Kennedy didn't need to raise his voice. The nominee's inability to answer spoke volumes. From political questions to free speech doctrines, the gaps in knowledge were undeniable. Kennedy came with the law, and the nominee couldn't keep up. This wasn't just a grilling, it was a revelation. And the question now is, will this nominee still move forward? If you enjoyed this breakdown, don't forget to like and subscribe for more videos.